Alex here with part 207 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0. If you haven't seen it yet, that is the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I am not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. And that's because, as you are literally about to watch right now in this video, my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of the 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. Mindset was extreme anxiety. I know that I told you guys I anticipated this was going to go smoothly. I didn't expect there were going to be any issues. It didn't matter. On the day of, I still had massive anxiety. What if I was wrong? There's a 1% chance she might show up. I didn't know what to expect. I didn't know if her family would show up. I didn't know how they would feel about it. I know that for the most part, I don't want to say for the most part, as far as I know, then and now in hindsight, her brother never had any issue with any of this. In fact, it wasn't a shock to him that it was occurring. And he did show up and he didn't oppose it. He didn't say anything. He didn't testify. He just went into the audience and observed and he watched. And I remember we went to a lunch afterwards with my family and he asked if he could come and I said yes. And I think that, back then I didn't know why he asked, but now I think in hindsight, it just kind of was a way for him to see, where our son was going to go, into the family he was going to go into. And I just think he wanted to observe that. And he was very polite, very respectable. And genuinely, it seemed like he cared about the best interests of his nephew. And if he didn't, there was all kinds of things he could have done to be, get in the way of that and disrupt it. None of that ever happened. So as far as I'm concerned, he's a great guy. He did show up, and the only reason that amplified my anxiety is I thought maybe his sister would show up, which was my ex, but she didn't. She didn't show up, and so my mindset before was very, very anxious, very nervous, and a lot of that I think was because I was worried that my son would see it, and that was a huge regret that I had, that I scheduled them at the same time. I shouldn't have done that. I should have scheduled them separately. Luckily, it didn't backfire on me and she didn't show up, so there wasn't a scene. But I was really nervous that she would show up and he would be in the middle of the conflict again, and that would have been because of my bad decision. But again, guys, none of that happened. Don't recommend you guys do what I did. I recommend you guys do the TPR first and schedule the adoption at a different date and time, because once the TPR is done, now your ex does not have a right to appear at the adoption. She's no longer a parent. He or she. And so that's the safe way to do this. And in fact, the attorney actually mentioned that he didn't think the judge was going to allow this. So he was shocked when she did. I think that the judge just did her research and found out that this case was not a normal case at all. There was all kinds of crazy stuff going on, multiple Supreme Court appeals, a publication by Justice Cherry. It just stood out to the judge probably as a totally different type of case. And by the way, the attorney, great guy. I remember meeting him. He did quell my anxieties a little bit, but I didn't really feel like he was a silver bullet. I felt like if my ex showed up, it was going to be a problem, whether I had an attorney or not. But I did want the attorney because I thought that it would give some semblance of separation between the litigant and the attorney, which is something that you just cannot do when you're representing yourself. So you've noticed that I represented myself all the way through the paperwork, but now that we have to appear in court and somebody has to talk and ask you questions, it's weird when you question yourself and when you narrate to the court. The court's used to a witness or a party, which in this case we're both separate from the attorney. The attorney asks the questions, the witness/party answers the questions. It's weird when those things are melded together. And I also figured it would be cheaper because we did all the paperwork and it was cheaper. I think the price was very fair. He did everything, both the TPR and the adoption, for $1,700. And that was for him to show up and just, argue, and that was it. So all of that being said, I think we can go into the hearing video.
Good morning. This is case D-534311. It is a request by petitioner Alexander Michael Falcone for the termination of the parental rights of Monica Ann Farrar Meserve. Counsel, kindly your appearance for the record.
Yes, Brian Steinberg, bar number 5787 for Armando Falcone.
Good morning and welcome. Dad, if you'll stand and raise your
For
right
Alexander Falcone.
If you'll raise your right hand, Madam Clerk will swear you in, and then you can be seated.
Solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Okay, so Alexander, you're the petitioner in this matter, is that right?
Yes.
The child issue is Armando.
Yes.
And it's Armando Robbie Falcone at this time.
Yes.
And how old is the child?
9.
Child is in good health?
Yes.
And the child was born when?
September 13th, 2006.
Where?
Reno, Nevada.
Okay. And the child resides with you?
Yes.
And where do you live?
11,000 Southeastern Avenue, Henderson, Nevada.
And how long have you lived there?
Since December of 2014.
Okay. And you are the natural biological father of said child?
Yes.
Okay. And you have primary physical custody and sole legal custody of said child?
Yes.
So the difference between stating these on being examined or questioned and having put them all in the paperwork, which if you've been following the My Docket series, you'll have taken a look at by now, is that with the paperwork, everything that I am asserting is hearsay. And now that I'm actually testifying in court under examination to the judge, my testimony is evidence. It's considered evidence. So what I say becomes the evidence that the court uses to make its decision. Sometimes people will wonder, well, hold on, why isn't this happen in other types of situations? Well, there are ways that the court can summarily grant and deny relief, and I cover that in the video hearings. And there are also ways in which you can bypass the court, which I think is covered in the video, default. So there are different mechanisms available that under different circumstances will allow you to get relief without even going into court. But this is a termination of parental rights, and in the statutes, one of the things that happens when you file it is there's a notice of hearing, and so because of the law, you can't really get around this part of the process. So even though my ex doesn't oppose the termination of parental rights, I still am required to go in. I'm still required to be examined, to testify under oath, and the court has to consider my evidence, which in this case is my testimony.
And Monica Ann Farrar Meserve, formerly known as Monica Ann Farrar, is the natural mother of the child?
Yes.
Have you been in contact with her?
No.
Okay. Now, when's the last time she's had any contact with the child?
Telephonic contact October of last year.
Okay.
Visitation November of last year.
Okay, November 2015, right?
Yeah.
Okay. And is she paying child support?
No.
Is she sending gifts?
No.
Is she otherwise trying to communicate with the child by letters, cards, or anything like that?
No.
Okay. And right now, Miss Farrar has a limited right of supervised visitation. Is that correct?
Yes.
But that supervised visitation was suspended. Is that right?
Yes, both suspend, yeah.
Can you give the court an idea? What were some of the problems you were having in a nutshell with Miss Farrar?
Inability to communicate. When communication did occur, it wasn't constructive. Problems with dental neglect caused him to have 5 crowns, 2 extractions. Not taking him to school.
Was CPS involved in the dental neglect?
CPS has been called 6 times, never by me. In fact, I didn't find this out until the dental neglect when a teacher told me that she had called CPS and asked me about it. At that point, I'd done research and found out. At that point, they'd been called 5 times, and then 1 more time from the psychologist over the physical abuse.
That was in Washoe County, correct?
Those 5 reports were in Washoe. There's 1 report in Clark.
Okay. And was there also physical abuse to the minor child?
Yes, she was hitting him in the face.
So that's one of the big disadvantages of representing yourself and being overwhelmed by emotions, is that you won't organize your thoughts in the order that they should be organized. Obviously, the types of abuse that you would want at the front would be the not taking the child to school, the dental neglect, and the physical abuse. You wouldn't want the communication stuff to lead. You'd want that maybe at the tail end of the explanation. But I also hope that people understand that this discussion on the abuse is kind of distracting, in my opinion, because people might think that this was the basis for the termination of parental rights when it really wasn't. It's going to come down to the abandonment. And if you take away the abandonment issue, it doesn't matter if all those things were believed by the judge, she still would deny the termination of parental rights. The dental neglect, the non-communication, the physical abuse, even the physical abuse, that probably would not result in a TPR. That would probably result in some kind of supervised visitation. So I just want to stress to not let yourself get too distracted by the allegations of abuse, because what is the beginning and the end of the termination of parental rights is the abandonment.
Okay. And do you know where she currently resides?
I can guess. I think she might be in Hawaii, but it's a coin toss because, I mean, it's 50-50. She might be there, she might be somewhere else.
Okay, have you tried to serve her at her last known address?
Yeah.
Was that in Reno, Nevada?
Yes.
Right, 6402 May Ann Avenue, number 77, Reno, Nevada?
Yes, that was reported by the secretary.
And have you ever known of any other address?
Never.
Okay. The nearest known maternal relative of the child is Joseph Farrar.
Yes.
That's the natural brother.
That's her brother.
And is he here outside?
Yes, he is.
Did he indicate, I mean, I don't know where he would have standing to do this, but you're not aware of him objecting to any of this?
He sent me a mail saying he wanted to appear but not to oppose the petition. His exact words were, but not to oppose the petition.
Okay. And the child is not of Indian origin.
No.
And do you work full-time?
Yes.
What do you do?
Software engineering.
Okay. And do you make over $30,000?
Yeah.
Okay. And you don't need public assistance?
No.
And the child's not receiving any public assistance?
No.
And okay, we covered that. So she has not provided child support since August 19th, 2015?
August, yes, that was the last garnishment.
Okay. And do you also believe that she has some personality disorders?
Yes.
And how did you come to that conclusion?
Just based on over the years, first thinking it was something wrong with me, that I wasn't communicating properly, then doing research and seeing that some of the things just weren't making sense, and finally, when I did my research on narcissistic personality disorder, and I dealt with the relationship in that way, by being as formal and emotionless as possible, I was actually able to get some progress. It was very limited, but that's actually something that the psychologist wanted her to be evaluated for if she did reconnect with us. He was going to work with the Second Judicial District Court on filing a report to compel an evaluation. But ultimately, she never tried to connect with us. So
I want to also jump in here to say what I said before, which is that I guess this is okay testimony. I just don't want it to confuse the viewers and make them think that it matters. Because, again, without the abandonment, even if an expert came in, even if an expert on narcissistic personality disorder swore up and down that my ex had it, it still, in my very strong opinion, would not result in a termination of parental rights. I still am convinced that the best that could have come of that is supervised visitation and maybe suspension of her visitation until she got evaluated. So don't go into court thinking that by proving a personality disorder or by even proving all of those other forms of abuse, including physical abuse, that you're going to get the same kind of outcome that I got here, because I just am 100% convinced that without the abandonment, this would not have occurred. And in fact, had they not mentioned anything else but the abandonment, had he left out all of the other forms of abuse and the narcissistic personality disorder testimony, I'm still convinced that the termination of parental rights would have worked. So it's interesting that he wanted to go into those two other areas, but in my opinion, it didn't matter one way or the other. It was all going to succeed or fail on the abandonment issue.
Now, you are married, is that right?
yes,
And what's the name of your wife?
Brittany Falcone.
And does she desire to adopt the child
Yes.
at issue?
Yeah.
And is she here today?
Yes, she
is.
is.
The child at issue here today outside?
Yes, he is.
Okay, so we're going to proceed with the adoption after we get done with this.
Yes.
Okay. So you are requesting that the court terminate Ms. Farrar's parental rights
Yes.
and that she has abandoned the child?
Yes.
And you believe she should not have any parental obligations and responsibilities when this is done?
Correct.
Submitted, Your Honor.
Do you have your order with you?
I don't. Did you?
I could prepare one if you
No,
want.
we can prepare it, but my assistant, we came in late on this case, and we thought maybe he had prepared it, but we're going to prepare it. We'll have it to you today.
Because, I mean, this has to be on file.
Yeah, we'll get it to you today.
Okay. Court finds abandonment, neglect, lack of efforts to support, communicate. It's been 8 months. And in the best interest of Armando Falcone, that his mother, Monica Ferrara, serve, her rights be terminated. Counsel to prepare an order reflecting same, and the case will be closed with the order.
And we'll submit this order first, and then we'll submit the other order.
It has to be today, yeah.
Okay, today. Yes.
Yeah, you can't submit them. Yeah, the TPR has to be submitted first.
Yes, that's what I'll do. I'll
Okay.
submit that today. And
Sounds
then
good.
wait a day
And
or
we'll
so.
go off the record on this case.
Okay. All right.
So we just have some documents to go over very quickly, guys. First, we have the notice of counsel. I think this should be called a notice of appearance. I've never seen it called a notice of counsel before. Anyway, I would have expected this to be a notice of appearance. And basically, it is a notice of appearance because he's saying, hey, I'm Brian Steinberg of the Steinberg Law Group, and I am here to represent Alexander Falcone in the above named action. And next is a certificate of service under Rule 5 indicating that this document was mailed to my ex. Next document we have is the order terminating parental rights entered by the district court judge. It isn't very long. She just states, number one, that we appeared before the court on the 9th day of August on the petition that I filed for an order terminating parental rights. And let's see here. The court, where is it? The court, having received evidence to the effect that the said minor child, Armando Falcone, is neglected within the purview of the law, in that my ex, the natural mother of the minor child, has failed, neglected, and refused to provide proper or necessary subsistence for the support and maintenance of the said minor child prior to the filing of the petition, that proper service has been made on the mother pursuant to the publication, and that the court has jurisdiction under the law to do so. It is hereby ordered, adjudged, and decreed that my ex's parental rights have been terminated. She's judicially deprived of the custody and control of our son, and that I retain sole custody of the minor child. The court has disposed of this case, and the court's disposed of the case by terminating my ex's parental rights. I filed, it looks like, one document that was a free filing, and so I incurred $0 in costs. My ex did not participate, so she incurred $0 in costs. I had an attorney who charged, I'm going to split it between the two cases. So for this video, I'm going to say it's going to be $850. Yeah, $850 in attorney fees. And my ex didn't participate, so she incurred $0 in attorney fees. As my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.